As MC Singla enters a decisive moment in its decade-long fight for updation justice, the Chief Justice of India in March 2026 issued a sweeping mandate on adjournments, an order that will shape the crucial Singla hearing on 9 April 2026.
Before Chief Justice Surya Kant, 11 Chief Justices came and went, but none in my memory shaped a judicial climate as favorable to bank retirees seeking a decisive verdict as the Honorable Justice Kant.
Welcome to this deep dive. Usually, when we think about monumental change at India's apex court, we picture dramatic speeches by the Chief Justice or some grandstanding with laudable intentions, but with little intent on the part of the judiciary.
Right, or performative promises to improve the system following sweeping public protests or condemnation by politicians and high profile public figures.
Exactly. But sometimes real seismic shifts happen with like a highly specific 3-page bureaucratic memo. A recent circular issued on March 18th, 2026 by the Supreme Court of India on the direct instruction of the Honorable Chief Justice Surya Kant.
This wasn't just any piece of paper, no. This was a circular with teeth laden with intent, measurable timelines, deadlines, cutoff points, upper limits, and review windows, to name a few. Its sole purpose is to nix the adjournment culture rampant in the hallowed courts of the apex court.
Today, we are looking at an official circular and an application annexure from the Supreme Court of India. It's dated March 18th, 2026. And the timing of this circular has huge implications for the forthcoming MC Singla case on 9th April.
And our mission today is to unpack how a massive judicial institution is fighting back against the endless drag of legal delays.
Okay, leaving MC Singla alone for a second before we dive into the new Supreme Court circular, first we need to understand what's driving Chief Justice Kant's adjournment initiative.
The scale of the backlog of cases stuck in the Supreme Court system, which is choking justice and the judiciary, is staggering.
Pendency has become one of the Supreme Court's most crippling failures, with over 88,000 cases now stranded in its backlog.
And for retiree, as those in the MC Singla case, this delay isn't just unacceptable, it's a quiet form of injustice. The one luxury seniors don't have on their side is time, yet adjournments, frivolous or otherwise, have sadly become the number one justice defeat device employed by advocates.
By aggressively regulating adjournments, which is really just a fancy way of saying requests to postpone a case, the Supreme Court has laid down the gauntlet to advocates to mend how they approach and conduct case through the apex court.
Right, it sounds incredibly dry, I know, but if you look closely, the circular is basically a weapon aimed directly at institutional gridlock.
Consequently, watching the Supreme Court wrestle with bureaucratic drag is, in and of itself, a masterclass in forcing a system to move. That discipline matters for cases like MC Singla and for the countless seniors still waiting for justice.
To drive the point home, since Shri MC Singla, deceased, and others first took the pension updation to court in 2008, more than 250,000 retirees have died waiting for a verdict. The delay isn't procedural anymore, it's bordering on the tragic.
Against this background, Chief Justice Surya Kant's counter adjournment mandate is like a blueprint for a machine designed to force momentum into a system with inertia that honestly naturally just wants to stall.
Because to stop infinite delays, you can't just ask people politely to hurry up or to play nice.
If you're enjoying this podcast, you can support the Bloggerian without spending a single paisa.
Just take a second to subscribe or share this episode with a friend or family member who needs to see this. It makes a huge difference and we really appreciate it. Thank you.
So, moving on, you have to establish rigid, transparent deadlines. So, okay, let's unpack this. How is the court actually enforcing this new timeline?
Well, they are targeting the intake valve first. The court calls these fresh and after notice matters.
So, essentially, the brand new cases that are just entering the Supreme Court system.
Yes. If a lawyer wants to postpone one of these, they can't just casually bring it up to the judge on the morning of the hearing anymore.
This tactic, known as ambush adjournment, occurs when a party in court introduces new, unexpected evidence or a novel legal argument, etc., at the last minute, often on the day of the trial, that the other side is unprepared for.
Over time, these adjournment tactics don't just slow the system. Um, they suffocate it. They leave courts gasping under mountains of pending cases, justice delayed beyond recognition, and legal costs soaring into the stratosphere. In the end, the message is unmistakable. Justice becomes a luxury good reserved for those wealthy enough to afford the wait.
Which is extremely worrying because such a tactic is exactly what ultimately collapses a court's daily schedule, as we've seen at the Supreme Court of India.
Oh, it's a nightmare. So instead, advocates seeking adjournment must now serve advance notice to the opposing side and submit that proof of service to the court before 11:00 a.m. on the previous working day.
Wait, so if I file at 11 a.m., the opposing side has just 1 hour, like literally until 12 noon, to email an official objection?
Yep, just 1 hour.
That sounds like it would create a frantic scramble every single morning. I mean, it is like calling in sick to a high stakes job, but you have to file a form by 11 a.m., and your rival co worker gets exactly 1 hour to officially object to your absence.
That is a great way to look at it, and that scramble is entirely intentional. By moving all that friction to the day before, the court protects its actual hearing time.
Right? But hitting that morning deadline is merely the first hurdle, right?
Totally.
Because the excuses themselves must now be absolutely bulletproof.
Oh, absolutely. Adjournments are now limited strictly to what they call exceptional circumstances,
And they define that pretty narrowly, don't they?
very narrowly. They specifically cite family bereavement or medical emergencies involving the advocate or the party in person.
So, no more I double booked myself or my dog ate my legal briefs kind of excuses.
None of that. And there are hard caps or limits now. For those fresh cases, a postponement can only be circulated once.
Really, just once?
Just once, plus 2 consecutive delays, regardless of which side is asking for them, are explicitly prohibited unless the case is actually actively listed before the court.
And you have to use a specific form for this, right? Like Annexure A.
Yes, Annexure A, you email it to a predefined address and you have to literally declare how many delays you have already taken. This is the mathematical limit of adjournment frequency. This metric alone tells you the Supreme Court is not playing.
They are strictly tracking it. So, if they're making it this difficult to postpone new cases, what happens to the older cases that have, been sitting on the docket for years for the MC Singla case, SLPC 5561 2016?
Well, that is where the hammer really falls. For regular matters, which are those older cases at the final hearing stage, absolutely zero adjournments are permitted. Watchers of MC Singla would agree this is the long saw to break the case needed to reach final disposal.
Okay, playing devil's advocate for 1 second, isn't an absolute ban on regular matter adjournments a bit ruthless? Like, what if something genuinely unpredictable happens to someone involved in a 5-year-old case?
Well, yeah, I hear you. But if we connect this to the bigger picture, you really have to understand the crushing weight of the backlogs the Supreme Court faces.
Right? The sheer volume is staggering. Watching the Supreme Court wrestle with bureaucratic drag is, in and of itself, a masterclass in forcing a system to move.
Yeah, it is. So, by imposing these unyielding limits, the institution is forcing systemic efficiency over individual convenience. Indeed, since Shri MC Singla first approached the courts in 2008, over 250,000 retirees have died waiting for justice. The delay isn't procedural anymore, it's a human toll.
They are deciding that the cost of endless delays to the justice system as a whole simply outweighs the flexibility of the lawyers.
Exactly. It's not about being mean, it's about removing the safety valves that allowed cases to just age into oblivion.
So, what does this all mean for you listening? Why should you care about an adjournment memo from India's Supreme Court?
Because watching how the highest court in India fights bureaucratic drag is really a masterclass in forcing systemic efficiency.
Right? It's not about vague goals. It's about 11:20 a.m. ultimatums, tracking every single delay, and eliminating those gray areas that allow systems to bog down.
Yeah, it is the ultimate tension in any massive system trying to course correct.
Which brings us back to that tectonic shift we started with. When a justice system prioritizes absolute efficiency by eliminating delays, at what point does a rigid, no exceptions rule risk steamrolling over the messy, unpredictable reality of those seeking a fair trial?
That is a very tough balance to strike.
For 10 grinding years, MC Singla and others, v. Union of India, catalogued in the court's sterile ledger as SLPC 55561 2016, had survived as a ghost in the judicial machinery, endlessly deferred but fiercely kept alive by valiant and resilient retirees.
But in approximately 18 days' time, the towering stacks of dog eared briefs and yellowing affidavits bound together by frayed cotton string will transform in an instant from a crushing symbol of paralyzed, delayed justice into an archive of vindication. The March mandate of the Honorable Chief Justice Surya Kant arrived in time to facilitate justice for retirees.
MC Singla was never merely a dispute over regulatory fine print. It was a bruising war of attrition between old, weary pensioners and the privileged monolith of the state and the banks. When the bench finally hands down its concluding decree on 9th April, a palpable exhale will ripple through the hushed gallery and in lakhs of homes across India.
On 9th April, the gavel's final echoing strike won't just settle a matter of law. It would break a 10-year fever, offering a quiet, hard-won testament that the arc of justice, no matter how agonizingly slow its descent, can still ultimately be forced to bend. Please subscribe and share if you haven't done so already. Catch you soon.